like to reconvene this meeting of the Shelby County Electoral Board hearing. I believe, Mr. Friedel, you should have received Mr. DeVore's brief.
I did.
Okay. I would like to state for the record that Susan Arthur, Brian Bach, and Jessica Fox, who make up the Electoral Board, are present, as are Christina Grant, objector, with her attorney Stephen Friedel, and Pam Helton, petitioner, with her attorney Tom DeVore. Ms. Grant filed an objection against Ms. Helton's petitions on the fact that none of the pages were numbered. We can dive right in, and Mr. DeVore did file a brief yesterday, which the Electoral Board has all received. So if either one of you would like to begin on your position, we will be willing to listen.
Before I start an argument, I want to make sure that we are at least in agreement on some of the things, if that's possible. But one of those is, there was not any objections, or as I understood them, to the facts of this. I want to make sure that we're not arguing about facts, that we agree what the facts are, and that this is simply an argument of the law.
I believe that's fair. The facts are that there were no page numbers on the petition, and we're arguing over the legal issues of whether or not that supports the objection.
And the tribunal or the board has a copy of the original petition, and that is considered to be in evidence then?
That is correct.
Okay.
Agreed.
Super. Well, question before this panel. I'm sorry, do you mind if I said?
No.
Question before this panel is simply this. Should a candidate who failed to number any of the pages of their nominating petition be permitted to have their name on a ballot? That's the issue that you're called to ask today. Tell you what, before I get into really the arguments, if I'm allowed, I'm going to do this. There's an elephant in the room. There always is an elephant in the room when we are on objections within the county level. I mean, this is an objection to a county office. All three of you are county officers, and we all know that. We all know what political party the candidate is. We all know what political party that each of you are, or at least Brian's boss is.
If you let the record reflect, I have no idea, but I guess everybody else does.
Susan was elected as a Democrat. Jessica was elected as a Democrat. I don't know what Brian is, but Brian's boss was elected as a Democrat.
Well, thank you.
So it's often, I think, considered a foregone conclusion, or that the fix is in. And look, if anybody thinks that we're looking for any advantage, or we want any advantage, we don't. We do not want any advantage in this. We do not want you all to consider party or anything other than the merits of this petition. At the end of the day, we're right. We're absolutely right. We want you to consider the merits of the petition, and we do not want there to be any consideration of what else does this mean.
I'd like to speak to that for just one moment. Regardless of what party affiliation I was elected under, I was elected to serve all people in Shelby County, and that is what I do. I could care less what party any person has behind their name. It makes no difference to me. I'm here to serve all people. And in speaking to that, I do want to let everyone in this room know, as a candidate myself, the fact that we're here, the fact that we even have to remotely think about potentially removing a candidate from the ballot is something that I do take very seriously. As the election authority, it is imperative to me that all election processes are done with the utmost integrity and ethical behavior. And so this is something that I take very serious. It's something that, unfortunately, everyone has a right to do. But regardless of political party, please know from, I believe, all of our standpoints, that would never even be something that would come into consideration.
And I hope that didn't sound like I was suggesting
No.
with you. I just want to make that just went through the air. All right. Like I said, we're right. We're absolutely right following the law. We're right, and I am absolutely 100% convinced that we are correct in this petition. And I don't feel that I've got any need to concede any ground here, but I'm going to. I'm going to concede a little bit of ground, or at least a little bit of the argument. And that is this. I think that that Mrs. Helton is reasonable in her desire to want to be on the ballot. I think she's reasonable to want to contest this. I think that it is reasonable to look at this and say this isn't fair. I think it is reasonable to say that being thrown off the ballot is an extreme result. And I think that is, it's not unreasonable. I think it is also reasonable what we are doing in suggesting, not suggesting, but arguing and saying that you need to follow the rules. And I can imagine a scenario where somebody who's watching this basically has a general understanding of what's going on and they're out in the community, and we're going to call them Jack and Jill so I can keep them apart. Jack says, look, I think this is unfair. I don't get it. I don't think it's fair. I think she should have been allowed to be on the ballot, and I think the voters should decide on this issue that shouldn't be done by a panel. And I can see Jill looking back and saying, you know what? The rules are the rules. And you got to follow the rules, and if we're not going to follow the rules, what's the point in having them? And if we're going to look at these rules and ignore them, the filing deadline is a rule too. So does that mean that we can file 5 days after the filing deadline too? Also, from one county to the next. If this county is more inclined to leave on the ballot, but the next county is less inclined to leave on, more inclined to follow the rules, then you get a mishmash of it matters more about what county you're in than what the law actually is. And that can't be. My point here is this. I don't want this to be about you three having to be Jacks or Jills. I don't want this to be about us trying to convince you that the right thing to do is to remove her, or the wrong thing to do is to remove her on like a philosophical opinion level. You shouldn't be drawn into that fight. We shouldn't be drawn into the fight. You shouldn't be called on giving your opinion about whether you would like to see her on the ballot or whether you would not like to see her on the ballot. That is not what you are to do. In this case, it is incumbent upon you to follow the law. And the reason I say that is there are 3 cases, and I'm going to get to them, I'm going to harp on them over and over and over again. There's 3 cases that have been decided in the appellate court. In all 3 of those cases, these are page numbering cases where the objections to the candidate's petition were page numbering objections. And in each of the 3 cases, the candidate did not number any of their pages. And in each of the 3 cases, the appellate court ultimately ruled that the candidate cannot, not should not, cannot be on the ballot. And in one of those cases in particular, which is Kabuli v. Thompson, and it's a case that I have cited in my Abudi v. Thompson, which is a case that is cited in my petition. That is a case where the only issue raised was failure to number. Nothing else. The court addressed much, if not all, of the issues that are in the reply, and the court decided that the candidate in that case, with these identical facts, could not may not, could not be a candidate on the ballot. So, there is no dispute of fact here that this is not a situation where she had numbered some of the pages and not numbered all of the pages. This is a fact scenario, a fact situation where there was a complete failure to the requirement that the page numbers be numbered. And that is a huge distinction within the case law. And I'm going to flesh that out more, but it is important to note at this point that that is the important factual determination to look at it, is that there was no attempt to comply with this section. So, the argument that comes in the reply, or the primary argument in the reply, is that we're talking about substantial compliance, and that she's otherwise substantially complied with the rules. Now, it's been said that coming close is good in horseshoes and hand grenades, but that's actually not true. Sometimes coming close is good in election law. Sometimes. And the courts have already told us which cases those are. And it's not necessary that you agree with the appellate court's decision, it's simply necessary that you follow it. So the court has told us that in election laws that sometime, it says that with some of these laws they're very serious about, and some of them not so much. In the ones that they are very serious about, they have designated those as being mandatory requirements. And in the cases where they have said that they aren't mandatory, they call them directory requirements. Now, in a directory requirement, the court isn't saying that they don't have to follow these provisions. They're simply saying that if you don't follow those provisions, that doesn't necessarily mean you're removed from the ballot. However, in a mandatory provision, it is required. It is a must. And if you fail to do a must provision, then the law as it's been interpreted said that you cannot be on the ballot. So, the three cases that I'm going to be harping on, the first one I've already mentioned was just L. Aboudi v. Thompson. Then there's Wallen v. Jacoby and Jones v. Doddendorf. Now, you can see the full case names and the full case citations are in paragraphs 4F and 4H of my petition. Now, all three of these cases are candidates where they had completely failed to do any numbering. Now, that being identical to what the issue is here. And in these three cases, the court found that when there has been no numbering attempt, that is mandatory, not directory. And in all of these cases, the candidates were removed from the ballot. I'm going to stop here for a second and point out a couple things. There are a couple cases, and they are mentioned within my initial petition, where they are signature cases, where the candidate who was objected to, they failed to correctly number their petition. Either they left them out, the case numbers got off some way, and in those cases, the court said that the question becomes, by attempting to number them, did they substantially comply with the numbering requirement? So those cases were not cited by Mr. DeVore in his reply, and the reason they were not cited by Mr. DeVore in his reply is because they don't help his position. Each one of those cases also suggests or tells us that with the three cases that I'm following is that in a case where you have done no numbering, it's not a decision. In a case where it's no numbering, it's mandatory, and that's the end of the discussion. So, and particularly I want to point out a specific quote coming from Jones v. Doddendorf, which is found in section 5 of that opinion. And this is the quote: "We do not believe that a candidate who completely ignores one of the statutory elements can be said to have substantially complied with it." I'm going to point out one more thing that, no, sorry, I just pointed out that one thing. I apologize about my notes. If I were allowed, though, out of the three cases, not allowed, if I were told I could only let you have one case, and only have you read one case, there's no question in my mind the one case that I want you to read, quite frankly I need you to read, is the L. Aboudi v. Thompson case. And the reason is because nearly every argument that Mr. DeVore is making has been addressed within that case. In that case, there is only one objection identical to ours, and that is a failure to number. In that case, there was no attempt by the candidate to number. So this is not like a similar fact pattern, this is an identical fact pattern. And in that case, they discussed substantial compliance, they discussed technical violations, they discussed nearly every argument that Mr. DeVore made. They were considered, and the court rejected them. So now Mr. DeVore is here making those same arguments to you, wanting you to come to a different determination than the appellate court found in that case, Aboudi, and you can't. It's not you shouldn't, you can't. I'm going to read five short passages out of the Aboudi case, because I think they're important. First, the single issue presented by the appeal is whether the provisions of 7-10 regarding page number is mandatory, justifying the invalidation of the plaintiff's appeal. So when I just told you that this is an identical case and there's one sole issue that was brought forward, that's the quote of the case that tells you I'm not lying to you. 2 paragraphs down in that opinion, the last line of that paragraph says, "Accordingly, we find that section 710 regarding consecutive page numbering to be mandatory." I'll say that another way. The page number requirement is a must, not a may. So the issue, whether this is mandatory versus directory, whether you can or can't, should or shouldn't, has been answered by the appellate court, and you should not, cannot be called upon to make a different legal decision, a different legal interpretation than the appellate court when they've already determined it. 2 paragraphs down, court says, Plaintiff argued below that he substantially complied with the provisions because he had enough signatures on the submitted page to fulfill the requirement. We disagree. They made the substantial compliance argument in that case. The substantial compliance argument was rejected because it was a mandatory requirement and there was no effort to fulfill the mandatory requirement. The end of the next paragraph, in relying on the Jones case that I just talked about, here's what the court said. Accordingly, we held that a candidate does not substantially comply with the requirements where he completely ignores one of the statutory elements. It goes on. We further found that numbering the pages of the submitted petition requires substantial compliance to prevent tampering, which preserves not only the integrity of the petitions submitted, but the election process in general, meaning that the court found that this was an important requirement, not just a technical requirement. And here's my last quote from El Abudi, and this one is a doozy. This is the second to last line of the El Abudi opinion, where plaintiffs made no attempt to comply substantially with the numbering requirement. The failure to do so, as mandated, requires invalidation of the nominating petition. Requires invalidation of the nominating petition. So folks, you have no choice. You've got to follow the law, and the law requires that you not allow Mrs. Helton's name to appear on the ballot. These are the arguments that I was attempting to make or been making in order to support my petition. I just received the response yesterday. I didn't file a response, but I'm going to go line by line along that and give my answers to it and the reasons why the arguments are not good or whatever. And let me suggest to you that you pull out the response as we go so that you can follow along, because I don't want to have to repeat each line of what the petition said, or the reply said. So paragraphs 1 through 4, that's just an agreement on the facts. We've already agreed that we're not discussing any facts. There's not any problem with that. This is all about the law, so those don't even need really to be mentioned. Paragraph 5, I don't have any issue with what is said there. Now, paragraph 6, here's where I do take an issue. The appellate court cases are not like a carton of milk. They don't have an expiration date. And actually, older cases are now considered established law. The newer cases continue to follow the older cases. So cases from the 80s and the 90s not only remain good law until the same level court or a high level court overrules the previous court ruling, but none of these cases cited in my petition or my objection have been reversed. Mr. DeVore makes no claim that any of them have been reversed, and not for nothing. I find it interesting that he's criticizing me for using cases from the 1990s, when 2 of the 4 cases he cites are from the 1990s. The third of the 4 comes from the year 2000, which is awfully close to the 1990s. And then the one case was 2008. I'm just thrilled to death that he cited, and we're going to talk about that in a little bit. Now I need you to read paragraph 7, and I need you to read it very, very closely. Because what opposing counsel is doing here is they're misrepresenting the holding of the cases I cite. He is saying to you the board can be justified in nullifying the petition. That's the word he uses, can. Now when he uses that word can, he's suggesting that you are not required to. So what he's telling you is that you can agree with my legal analysis of the Ella Dooley case, the Jones case, the Long case, where the courts found that numbering requirement is mandatory. You can agree with us that the candidate in these cases made no effort to comply, and the candidate in this case made no effort to comply. And that while you, according to them, could rule for me, they suggest that you're free to rule otherwise. And let me again then quote the Abudi decision, where it says, the plaintiff made no attempt to comply substantially with the numbering requirement. Failure there, so as mandated, requires invalidation of the nominating petition. So in that paragraph 7, he's by suggesting to you that you don't have to do this, you can do what you want, you can get Jack or Jill. He's misstating to you what the law of the land is, the law of the state is, the valid law is, and he's not supposed to do that. Takes paragraph 8. This is where Mr. DeVore cites the single case. This is a 2008 case. Really pleased he did that. First, let's talk a little bit about what that case actually was. This case is a nominating paperwork case where you're required in the resolution to date the resolution, right? So one of the requirements is that you've got to put the date on it. And in this case, the date that they wrote on the resolution was April 6th. Then the objector said, well, no, April 6th was not a correct date. And that was the basis of at least one of the bases for their objection. The candidate came back and said, you're right, it wasn't April 6th, it was April 5th. And the tribunal accepted that explanation. In a nutshell, the majority held, even though they got the date wrong, they made an effort, and that was close enough. Now, I don't really want you to pay attention to this case that much because you have 3 directly on-point cases to listen to, but this is where you look at the substantial compliance argument. Not, did you do most of the requirements? It's saying in that one requirement that we're having a discussion about. In this case, does the thing have to have a date on it? They came close. They tried and came close, and that was substantial. That was close enough. That was good enough. That is not the argument that Mr. DeVore is making, where if there are 9 or there are 10 requirements and doing 9, but completely failing to omit 1, no matter how important that 1 may be, he's arguing that that's substantial compliance, and that is not what is meant by substantial compliance in these cases. As a matter of fact, there was one case, and I'll get to it a little lower, where they made that exact argument that we did enough of the requirements, and that's okay, and the court said no, absolutely not. And I'll quote to that when I get to that point in my notes. But here's the thing that I really like about the duty. I got to figure out something else to call this thing because I'm going to trip up on it each time.
Thompson?
Thompson, okay. In the Thompson case, thank you, Tom.
No problem, sir.
So in the Thompson case, the civil court specifically looks at the Thompson case. If you read the civil case, you will find that in the case law, that is one of the cases that they cite to, and they hold it to be good law. They follow it. So even though this was a 1997 decision, which Mr. DeVore says, well, that's old, don't listen to it. The 2008 decision, which was the newest decision that anybody's quoting here, said we're following a duty, we're following Thompson. That's still good law. That's the one we follow. So, not that I really cared that much about the old cases argument that he made, but it was a bad argument before. But now, with the fact that they're following Thompson case in 2008, it's a completely invalid argument. Let's go to paragraph 9. This is the Welch case. In this case, the candidate was required to file a statement of economic interest, and in that case, they omitted a payment that was, by all accounts, agreed that needed to be on the statement of economic interest. My first point here is that this case doesn't give us any guidance on our issue, on the page numbering issue. But the principle of law that was cited in that paragraph is that the placing on the ballot is a substantial right and should not be denied lightly. Okay, we agree with that. We agree that it is a substantial right, and it should not be denied lightly. We'll also agree that the Welch case, that holding is not new. That has been the state of the law in Illinois about as long as we've been having election cases. And when the 3 cases in Thompson and Wolin and Jones decided those cases, we have to assume that they also agreed with that statement of law, that it is important, it isn't to be taken lightly, and in each of those 3 cases, they decided that when you fail to do any numbering at all, no matter how grave the situation is, no matter how seriously they're taking it, they said you can't still stay on the ballot. Paragraph 10 cites Ferguson. This is a case where candidates were decided by a caucus, and the losing candidates complained that the caucus procedure wasn't used properly. Fine. That case factually has got very little to do with what we're doing here. But what is important about that is that that case was decided in 1993, and so then when Thompson decided their case in 97 on the same issues, we're assuming they're aware of that 93 case, and that 93 case didn't do anything to stop them from finding against the candidate in the 1997 case. So in paragraph 11, they cite Courtney. The Courtney is suggesting that if a provision is mandatory, then the court's supposed to look at the legislative intent. I agree with that too. I just don't understand why Mr. DeVore is making the argument. The court in Wolin did determine the legislative intent. And when they did it, they decided that the legislative intent said it was mandatory. And this is the language that they used in Wolin. In determining whether a provision is mandatory directory, we must ascertain the intent of the legislature through the language of the statute itself. Okay? So they already did this, and this is what they said about it. We hold that the page numbering provision of section 10.4 is mandatory and not directory as a matter of law. So they decided for us what the legislative intent was, and they decided the legislative intent said this is a mandatory requirement. And so even though Mr. DeVore would like to try and convince you the legislative intent doesn't come to that conclusion, you can't be a Jack or a Jill. You've got to follow the law. And the law says that it is mandatory and you can't do it any different. The Courtney case also is not a page numbering case, and I keep pointing that out. I feel like a broken record, but I think it is important. When you've got 3 page numbering cases, directly on point cases that tell us how to do this, and then you look and grab at other cases that are not page numbering cases and try to like transfer that to this, that's just a bad way of doing things. So, let's look at paragraph 12, and I want you to read this one carefully, please. Plain reading of that statement suggests that in all cases, if the board does not find fraud, they can't strike the name from the ballot. That is not the law. It's not close to the law, and that is a misinterpretation of the court's holding in the Courtney case. In the Courtney case, what happened was the court pointed out that there was no reason to believe that by Courtney filing his statement of candidacy and then filing his economics or his second thing later, that he wasn't doing it fraudulently and he wasn't doing it to gain any advantage. Okay, that's in that scenario, the court mentioned that. Super. In the 3 cases where we've got page numbering cases, the court does not at all suggest to us that we need to look at fraud, we need to find fraud, and that fraud was in any way considered, particularly in the Thompson case. So this is a requirement that Mr. DeVore is simply making up for us. You do not need to find that anything about fraud. You simply need to find that they failed to do a mandatory provision, and that mandatory provision was important as the court said. So, look, if the courts have never had a page numbering case before, if this case were what we call a case of first impression, I absolutely get it. He could make those arguments to you and try and convince you that you ought to be looking at fraud. The problem with that is this isn't a case of first impression. The issues have been decided before. You don't do it again. You just follow what the judges have already told us the answer is. Paragraph 13 and 14, they cite the sigil. It was the same paragraph, same case, paragraph 8 above. And in this, it looks like he's arguing that violating the page numbering provision is a technical violation, and I guess there's some suggestion that because it's a technical violation that means something. The court ruled on this. The court ruled that Mr. DeVore's position didn't stop this from happening, and I'm talking particularly in the Jones case. And here's the quote. Plaintiffs argue that their failure to number the pages of their 12-page petition was similarly technical and did not justify the invalidation of the petitions. We disagree. The court addressed the technical issue. This is just technicality. Don't worry about it. And they said when they did that, it's mandatory. You've got to follow it. And if you don't do anything to do it, you're not following it. You're not in substantial compliance with that section, and you can't be on the ballot. Then, paragraphs 15 through 24. This is laying out what the law is. Got no issue. I think they adequately described what the law was. Paragraph 25. The reply states that the page numbering is one of the many requirements. Now, it's not that I don't disagree with the statement, but it's the same argument I made before. Which, no, I'm sorry. Not the same argument I made before. Let me actually read this because I wrote it better than I just said it. In paragraph 25, the reply states that page numbering is but one of the many requirements. I don't disagree with that statement. But it would be more accurate if paragraph 25 had read as follows. Page numbers is one of the many requirements, but it is a requirement that the courts have determined to be a mandatory requirement. Now that would be an accurate statement of the law. Paragraph 26 says the question for the board is whether substantial compliance is sufficient to guarantee a fair and honest election. That is absolutely not the question before the board. The question before the board is, will you follow the case law in cases that have addressed the specific issue of page numbering, where the courts determine page numbering to be a mandatory requirement, And the failing to page number, regardless of compliance with any of the other provisions, requires you, as a matter of law, to remove Mrs. Elton's name from the ballot. That is the question before you. You can ultimately say that we could have had a fair election, we could have had a wonderful election, it would have been more fair, more genius. You could be a Jill all day on this, it doesn't matter. It's not how the courts did it when they addressed this very, very issue. And you need to do it the same way the courts did it. Additionally, paragraph 26, Mr. DeVore is making the substantial compliance argument again. Now, in this case, in this way he's using it here, he's using it improperly. So what he's basically arguing to you is the 9 out of 10 argument that I made before. If there are, for example, 10 requirements, they do 9 out of 10, he's suggesting that's close enough no matter how important number 10 was. Now, that argument got made and rejected. But what the argument where they talk about the context of page numbering, here's the way to appropriately use that term. And that is if the candidate did some numbering, but it was incomplete or faulty, then in that circumstance, the candidate could argue to the board that the numbering that they did do substantially complied with that requirement. And then the objector would be free to argue that the numbering was so erroneous that it didn't comply with the requirement. And at the end of the day, that would be the argument of substantial compliance. The argument of, because they did 9 out of 10, and that means substantial compliance, is not what any of these cases are talking about, but we're saying that they were in substantial compliance with the petition. Paragraph 27. The reply suggests that our objection needed to allege actual prejudice, so this needed to actually hurt us in some way. There's nowhere in the statute that this is a requirement. There's nowhere in the case law on page numbering that this is a requirement. And quite frankly, this is a requirement that Mr. DeVore just simply made up. Took a shot to see if you'd bite, and I'm saying you don't bite, there's a hook in that word. Follow the law doesn't say a thing about having to allege actual anything. Page 28, or paragraph 28, it suggests that our decision doesn't raise a substantive issue. First of all, I don't know what that means. Second, like paragraph 27, that's neither in the statutes or the case law as a requirement, so again, they're just making this up. But finally, the Jones case says, and I stated this one above, as stated above, in addition to aiding in identification, we believe a legitimate objective of the numbering requirement is to prevent persons from tampering with the petitions. In addition, it is conceivable that the sanctions imposed for noncompliance with section 10-4 of the election code will further the state's valid interest in protecting the integrity of the electoral process by helping to ensure the candidates will strictly comply with the requirements of these election laws. The appellate court seems to believe that these are more than merely technical violations. Paragraph 29, that's shorthand for the technicality argument. I've already addressed that far too many times. Paragraph 30. In Helton, it says if Helton satisfied the other requirements, except for the page numbers, then there's substantial compliance. This is the same argument that I'm making about Thompson. Both that statement and the Thompson case can't both be right. It's one or the other, and Thompson was the appellate judges. This argument is Mr. DeVore. Go with the judges. Paragraph 31. I've already fully addressed that in paragraphs 28, 29 above, but as well as all over the place when I'm arguing. Paragraph 32. I don't disagree with the assessment, but I got no desire to try to convince you to agree with me. Because whether or not that statement in that paragraph is true or not, it has no relevance in light of the 3 big cases that I'm relying on. If you want to pay attention to paragraph 32, that calls you into being the Jack or the Jill. Finally, paragraph 33, I've addressed this argument fully above, specifically when I was talking about paragraph 26 above. The law is on our side. The law to these facts are on our side. Mr. Work will try to convince you to get off of that path. If that's a bad suggestion for you to do, it's one that I don't think you can do. We're asking that you not do it. We're asking that you remove Mrs. Helton's name from the ballot as the law requires.
Let's remember that when an appellate court hears a case, what they're doing is making a determination of whether or not someone underneath them, in this particular circumstance, when the case is cited by my colleague and I is whether the electoral boards made the correct decision or not made the correct decision. They give deference to these boards in making decisions. My colleague also talks about at the beginning, he talks about, old law being good law. That's generally true when you deal with real estate, because that's been around for billions of years, and so we use that misnomer not all the time. I think all of us sitting in this room have probably been on this earth long enough to appreciate that if anything has changed in the last 2.5 decades, it's elections and how elections are processed and how they're handled. There's probably nothing that's changed more than that. So to make the suggestion to you that your deference and your decisions should be solely reliant upon laws that are 2.5 decades old as it relates to elections, I completely disagree with that characterization. Again, if we were dealing with a real estate property line dispute or something, then I'm going, yeah, old law is good law. Now I'm asking you to pay attention to laws that have progressed since the 1980s and 90s, not for the basic premise and the basic philosophical types of cases like I've cited to and I will point to again. My colleague points out I used a case from '92. I certainly did. Place on the ballot is a substantial right. Should not be denied lightly. That's important. That's never going to change 20 years from now, 50 years from now. Whether or not when we're dealing with this issue of page numbering and how this board should look at that, that has in fact changed. And what's changed is in court cases that I've cited where they talk about mandatory. What's mandatory? What's directory? Whether or not something, if it's not followed, you should use your discretion and say, no, you cannot be on the ballot. That has progressed in the last 2.5 decades. And again, I can cite the cases to that, but I would ask each of you to use your time on this earth and have watched elections as times passed and say, yeah, that's changed a lot. And I think we could at least agree on that. Some of the cases talked about, again, the Thompson case that my colleague talks about. Let's keep in mind that the Thompson case comes from, it looks like, 1997. He also probably points out that that case was talking about Section 7-10 of the Election Code. Section 7-10 has a lot of the same language as Section 10-4, but he brought this petition specific to Section 10-4. I don't believe it's fatal that he uses cases from 7-10, but certainly there's a disconnect there. But again, I think the most important thing for you to keep in mind as it relates to some of the cases that my colleague cites is there, as it relates to this specific issue of signatures, they go back over 2 decades. As we all know, and again, I think Mr. Friel points out, the utmost importance of the election code and for your role is to maintain the integrity of the process. That has to be your ultimate goal. I'm asking you, when you make a decision, to keep that as the primary goal, is keeping the integrity intact, whatever your decision. Again, my colleague, having been a lawyer a long time as well, knows that that's not the conversation he wants to have with this board. He wants to point you to 3 cases from 2.5 decades ago and beat on the table that says you have to follow those cases. And the answer is you don't. You can distinguish those cases, you can look at the laws that's progressed, and you can make the decision that you believe upholds the integrity. Now, I've done it before. I've been a lawyer long enough to know if I got cases that I think I can just make people think you've got to follow this, I've done that before too. I've done it in a lot of cases, but you know what? This case is bigger than that. This case is about an election process in a time where elections are extremely important in this state and in this country, and I believe that not getting bogged down in a case that I can distinguish with the progress of the law is not something that this board should do. Again, I cited in paragraph 10, the general purpose is to make sure we have fair and honest elections. To that extent, my colleague doesn't disagree that this is not whether we're going to have a fair and honest election. He's saying it's a mandatory requirement. They have to follow it. If they don't follow it, you have to kick her off the ballot. And again, that's not the case of the state of the law right now. Paragraph 11. This case is only 20 years old, but it makes the point, my colleague points to it, but I don't think he points to it correctly, where we talk about the use of the word shall. And I'm going to jump real quick to paragraph 15 of the election code. Paragraph 15 on our response, it's part of the election code, where it actually talks about section 10-4. Talks about the requirements of the petition that has to be filed with you. consist of sheets of a uniform size, and, signatures, headings, name of the candidate, etc., etc. And it lays out. And it goes on from paragraphs 15 to paragraphs 20, I believe, 3, that talks about the requirements. And one of those requirements is that you number the pages. It's absolutely in there. There's no doubt about that whatsoever. But the case law, as it's progressed, talks about how, the word shall, which is in the election code, though generally regarded as mandatory, a mandatory requirement, does not have to be so fixed or inflexible that its meaning can be, in fact, it can be made depending on the legislative intent. And what is the legislative intent of the election code? To make sure that we protect the integrity of the electoral process and we have fair and honest elections. So that case stands for the absolute proposition of what we're proposing here. We also talked about the Siegel case. Substantial compliance is acceptable when invalidating charge concerns or technical violations do not affect the legislative intent of fair and honest elections. There's no page numbers, ladies and gentlemen, we know that. The question for you today, quite simply, is the fact that those page numbers aren't on there, is that such a material non-compliance of all of the requirements of the election codes under these facts and circumstances that are in front of you today? Not what may have been in front of the Thompson court over 2 decades ago. In front of you today is this board with the discretion. Do you feel that that page numbering was a material enough deviation with all the other facts and circumstances that this my client should not be on the ballot? That's the issue. It also points out in the Siegel case that substantial compliance with this code is acceptable when the invalidating charge concerns, again, a technical violation of the statute that does not affect the legislative intent. I've listed in there for you all of the requirements. The only requirement they've raised is the page number. And it is a requirement, as we pointed out and my colleague pointed out. And he tries to say I'm trying to throw this board off. I'm not. He's not alleged any substantive issues. He says he doesn't know what that means. I believe he does know what it means, but it's just a part of my client's argument he doesn't want to discuss. Is, okay, we have this technical page numbering thing that occurred. How has that impacted the electoral process? Where is the harm? Where is the violation? Where's the integrity at of if my client gets put on the ballot? They don't bring it up. They don't want to talk about it because they know there isn't one. They're merely going to continue to point back, and I know my colleague, when he gets a chance to reply, he's going to go back to you and he's going to harp on these 3 cases from 2 decades ago. And you know what? 2 decades ago, we didn't have the cases that came after that that says the use of the word shall, while it is mandatory, is not so inflexible that you can't, if you choose, the 3 of you say, you know what, that's a may, because if we're still satisfied that legislative intent has been satisfied, our election process will be fair, then you can leave her on the ballot and you have that discretion. These cases don't stop you from doing that. My colleague tries to tell you they do, they don't. And lastly, again, I just want to point out to you, say, from the 2008, from the Siegel case, I think that's really important. It's only 12 years ago, where it talks about, I'm going to flip to that particular page, where again, he talked about it again. A technical violation does not affect legislative intent. You can say that that violation is not so egregious that she has to be kicked off the ballot. That's my client's position. It's pretty clear what she's asking for you to do. We're asking for you, again, there's been a lot of that going on in various different ways across this country and this state for various reasons in the last several months. And what I'm asking this board to do is use its own discretion. Whatever you think is right, my client will respect. And not to be pointed to some narrow fact pattern of a case 2 decades ago and saying you have to do that, because you don't. My client knows, my client believes that. I know Mr. Friedel knows you don't. You are within your bounds and within your authority and within your discretion to say this violation is not that egregious and we're not going to kick her off the ballot as a result. Thank you very much.
Well, the last argument this board makes says the lack of page numbers is not that important. It's not that important of a requirement. It's not that much of a big deal. The court disagreed. The court said the page numbering is important because it makes sure that there's not fraud within the election. It makes sure that we know how many pages there were in the signatures, we know how to refer to them, and it keeps the person from being able to add or remove pages. So that is what is in the rationale of the court when it says this is an important requirement. It is when I cited to it, when I read the court's response, it said it's necessary for fraud, and it's necessary because we need to make sure that under the election code that we tell people you got to follow the rules, and when we tell them this is a rule you got to follow, and then you don't follow it, we can't say we don't care. If that is the case, then they should be allowed to file for office now even though the deadlines have passed. Because why not? You would allow for a free and fair election. Why not be allowed to file all the way up to the day that you print the ballots? Why not let me file all the way up to the day that the election is held? So we can disagree about how important or not important this is, but the problem is the court already decided to tell us what was important and not important, and they said this is important. It is so important that the legislature wanted it to be important. They called it a shall, and they said it shall be mandatory. And when the courts interpreted it, they said this is a must-do, not a may-do, and any time that you completely fail to put a page number on the thing, you are required to be knocked off the ballot. Required. So while Mr. Dvorak wants you to use your own discretion, I'm saying do not replace your discretion with the discretion used by the appellate justices when they decided these cases on these facts. And I'm going to rely on you, Mr. Bach, to help explain, if necessary, what precedent cases mean and overturned cases mean, and when you should pay attention and when you shouldn't, and that you can't simply say, that thing's old, so don't pay attention to it anymore.
Are you done, Mr.
I think I'm done, but if you can have just one more moment, make sure I didn't miss something.
Okay.
Yeah, I'm done.
As I say, a couple of things I want to point out. One, Mr. Friedel suggests, well, if you don't enforce this fact pattern, then we have a free-for-all and somebody could file a petition today. That's ridiculous. Because if someone filed a petition today, guess what? They could have been out collecting signatures for the last couple of weeks after the deadline. My client filed it within the deadline, so obviously the signatures that she got didn't happen well after the deadline. So those fact patterns of whether or not something is a issue, whether or not, as I'm reading the case, in the absence of fraud or showing the merits of the election were affected. You don't have any of that here. My client submitted over 200 and I believe 85 signatures. She only needed 50. So looking at that fact pattern with the situation you have in front of you right now, not some hypothetical that my colleague might create, if you were to, that's like a scare tactic. That's like trying to say if you don't do this, then all of a sudden you're going to open free-for-all. I've heard those scare tactics across the state for 3 months, and they're not effective, and I don't want one of my colleagues doing that, but so be it. This is a fact pattern. You have it. You understand what the facts are. 285 signatures, she needed 50, didn't have the page numbers. In your discretion, all three of you, you have the discretion. If an appellate court ruled on a different fact pattern, is it authority to consider? Absolutely. Now, I'm not asking my colleague here who's on this panel to use he's here as an electoral person. He's not here as an attorney, but he has an attorney background. I respect that. It's authority. Certainly is. It's not as controlling as my colleague would suggest to you because the facts are different, the law has progressed, it's developed, and I'm asking you to use your discretion on whether or not if she stays on the ballot, has your election here in Shelby County, has it been prejudiced? Is it going to be impartial or unfair? The answer is no, and that's why they didn't bring it up, so I'm asking you to leave my client on the ballot. Thank you.
Are there any public comments? Would you like to say anything?
Well, it's up to you.
Okay. Can I say something? I did miss that, and I regret that. But I do hope that you don't take away the choice for the people because of my missing that. So, thank you.
Can I say something also?
Yes, you may.
Okay. My concern as a voter and taxpayer in Shelby County is that I've been affiliated with the Shelby County Circuit Clerk's Office, the Sheriff's Department, the Probation Department. It is very important that whoever is on that ballot understands the attention to detail. And I feel like the page numbering is a requirement. As a taxpayer, I want a fair election for all taxpayers in my county, whether it's Democrat or Republican. But I also want that candidate to understand the importance and severity of following detail and attention to detail in the office of the circuit clerk. Because our county and constituents are very much impacted by that.
Anyone else? Okay. I will say that since June 8th, I have read more case law than I ever thought humanly possible. And I have no legal background, so a lot of it is Greek to me, but in the basis of things, I did get the general opinion or consensus. I will agree with you, Mr. DeVore. Elections change almost on a yearly basis. When I started working for Shelby County, we had punch cards, and of course, Floridian voters couldn't vote correctly, so that went by the wayside. Election code is antiquated. It needs major overhauling and updating, but I don't anticipate that that will happen in Springfield or the United States anytime soon. With that being said, on page 8 of the 2020 Illinois State Board of Elections Candidates Guide, it does state that the petition sheets must be original, all one uniform form size, and numbered consecutively, beginning with the top petition signature sheet as the number 1. I have spoken with people at the State Board of Elections. I have a case here that heard by Ken Menzel, who is Chief Legal for State Board of Elections, regarding signature requirements. Their opinion was that the candidate would be removed from the ballot. I was told by another person at State Board of Elections that his understanding is that page numbers are always required. That, you know, if you misnumber, that could be considered technical, but it is required that the pages be numbered. I have another page out of that candidate's guide that's full of shall. Unfortunately, when I'm told shall, normally I'm pretty sure they means that they want me to do it. I don't know how my constituents feel, but that's just kind of some, studies that I have done. Like I said, I don't want to see anyone removed from a ballot for such something that might seem minuscule and technical, but unfortunately it is stated everywhere you look that you have to do that. I know that you've worked hard to get those signatures. I know you have a lot of people that want you on the ballot, and that is why this is something that's so hard. And yeah, it's just a situation that I don't think any of us want to find ourselves in. But we are tasked with the responsibility of making a decision based on things that are in front of us and laws that direct us to do so. So I will give Susan a chance to speak.
I agree with what you say, and in my experience, anytime it says shall, that means we must do it when in our, anything from the Supreme Court, it says or whatever shall do it, that means must. So it's, it is a bad, situation, but that it seems to me that it should, is not encouraged.
First, I want to thank both attorneys for the time and effort made in preparing the briefs. Those were very helpful. And I want to say right off the bat, one thing the council said early on is looking at decisions out there regarding electoral requirements, petition requirements. They're all over the map. I have been stunned and surprised that a page that has an expired notary stamp or the notary forgot to sign it, those can be seen as mere technicalities, and the petition can be preserved. So I'm aware of the diversity and the volatility of those decisions. I cannot say the same for this issue. The cases that I have reviewed on this issue have been very consistent that it is a mandatory requirement. I have seen a handful of cases where it was not found to be so, but those were substantial compliance cases. The one that sticks in my mind is there were 394 pages, one of which missed numbering. All the rest were numbered. So here, I think we can agree there was no effort to comply with this part of the statute. And I'm not saying that was intentional. That's just, there was no compliance. The other thing that we've spent some time on is shall. You know, typically when statutes indicate shall, that indicates a mandatory legislative intent. But two, in looking at this statute, when the statute tells you what will result if you fail to complete this requirement, the appellate courts have found those to be mandatory in nature. As far as the page numbering itself goes, and I think we can all agree the legislative intent here is to provide a fair and honest election. I think we can all agree on that. What is curious to me here is the page numbering and binding requirements. These operate together. They operate together to prevent tampering, but the page numbering has a separate effect, because if you don't have pages numbered, you could never tell if an original page was later removed or an additional page was later added. To me, that reasoning, despite being decades old, I think that reasoning in terms of assuring that internal clarity and being able to find any sort of fraud with the numbering, I believe, makes the lack of numbers here fatal to the petition. My position is that they should be invalidated.
Do you want to make that motion?
I would make that motion at this time.
I will second that motion. That unfortunately, due to the lack of numbering the pages, I feel that it does invalidate the petitions. All those in favor signify by saying aye. Those opposed, nay. Motion carries. We're going to briefly recess so I can prepare a written decision,
Yes, ma'am.
and I will be back shortly.
Okay, thank you.
I'm not going to shoot you down, guy, but yeah.
Yeah, better.
Yep.
For the record,
Good job, Tom.
You
for the
too, sir.
record, we're going to continue live streaming until they come back and
Okay.
issue
I
them.
appreciate you letting us know that. Thank you.
So everybody can hear you if they want to hear you.
I hear it, yes. Thank you for letting me know that.
Some people forget.
Okay, that must be, I certainly know the name. I don't know that I can go back.
Yeah, I know what you know. I represent a lot of banks.
Okay.
Yeah, a lot of banks, a lot of real estate, business type of stuff.
Right.
And most recently, constitutional law.
Oh, okay.
I can be governor.
Oh, okay, I didn't put that together, right?
Yeah, that's sweet.
Take a number. That's right. Oh, okay, yeah. Yeah.
And that's how I got to know a lot of these guys.
Sure.
And I genuinely get to have them took it serious, and I appreciate it.
Right. Yeah. That was the time. I know.
I know, I mean, we're never gonna, yeah, I won't be afraid to give up and find, you know.
No, it's a good case. Yeah.
But it wasn't good.
I understand.
I wanted to let you know.
Well, no, thank you. The last time we
After they're like, go for a ride, you know.
the notary stamp, I think, was out of date or something crazy thing like this. They can patch this thing together so you can have the wrong person signing it. It can be an outdated stamp. They can be on the wrong page. They can be out of, you just think, how can this happen?
I understand, yeah, it's just.
But other things they can. Okay, I'll keep that.
Yeah, thank you, sir.
I saw you were saving
Sign this, please, and then, if you don't mind, I'll have it down, and probably make about 6 copies of this.
Okay.
So, and then if you would, like I said, about 6 copies of that. Okay, I will get copies of the written decision so that you can each have a copy
Yes,
and then
ma'am.
proceed with whatever direction you choose to go. Once again, I appreciate everyone's time here today. Fair and honest elections are extremely important, and I do want the public to have a sense that elections are operated fairly and with integrity, and once again, I regret that we all find ourselves in this situation. I'm sure that you know that you do have recourse, and even though it's possible that Ms. Helton's name will not appear on the ballot, she can file and write as a writing candidate, so.
We've discussed that, thank you, ma'am.
Okay. I would welcome, comments again from anybody that would care to say anything. And if there are no comments, this meeting is adjourned. I appreciate everyone's time and effort that you put into this. So,
Thank you, ma'am.
thank you.